幾多上先啊？
好啊好啊，慢慢。OK。
我到後面啦，等陣啦。
好啊好啊。
後面記得前面影晒先。
係借一借俾後邊。
都係少少啦，會影晒。得未？幅畫，我都再低少少。
好，各位傳媒朋友影晒相未？
等多陣。
OK， 好。
stand 撳光，
撳高少少，得唔得？咁好唔好啲？各位。呢度啊，爸。OK， 各位傳媒朋友，大家好，我係黃文傑。咁多謝大家今日早上親臨呢個記者招待會。咁香港大律師公會主席杜鑑坤資深大律師會先用廣東話同英文作開場發言，回應政府建議提請全國人大委員會根據香港國安法解釋海外律師及大律師可否參與相關案件嘅工作。係啦，之後咧我哋會有一個時間係回應各位記者嘅提問嘅。首先有請主席。係，各位傳媒朋友，大家好。國安法第65條明確咁定明，全國人大常委會對國安法係擁有解釋權。全國人大常委會可按情況喺適當嘅時候行使解釋權。全國人大常委會行使解釋權嘅時候，無可避免會引起一啲對香港法制嘅討論同埋批評。國安法係相對較新訂立嘅法例。公會希望國安法條文裏邊尚有不明確之處咧，將來係可以由香港法庭去釐清。藉國安法第65條由全國人大常委會去釋法，有關權力應當審慎地行使。大家亦都可以留意到喺昨日終審庭頒布嘅裁定書第33條裏邊都講得好清楚，香港特別行政區嘅法院全力捍衛國家安全，亦會按照國安法有效地採取行動，以防止打擊任何危害國家安全嘅行為或者活動，並施予懲罰。公會堅信香港嘅法院同法律界將會繼續履行維護國家安全嘅責任，維持法治同埋保障司法獨立。我而家用英文簡短咁重複一次。Thank you very much for attending this stand-up today. The power of the NPCSC to interpret the Hong Kong national security law is expressly provided for in Article 65 of the NSL. The NPCSC is entitled to exercise such power in circumstances that it sees fit. The exercise of such power will inevitably attract discussions and also criticism of our legal system. The NSL is a relatively new piece of legislation, and we hope that any ambiguity can be clarified by our court in the future, and the power to interpret under Article 65 can be exercised sparingly. I would also like to emphasize that, as stated in paragraph 33 of the determination by the Court of Final Appeal yesterday, the courts of the Hong Kong SAR are of course fully committed to safeguarding national security and to acting effectively to prevent, suppress, and impose punishment for any act or activity endangering national security as required by the NSL. We firmly believe that our courts and the legal profession will continue to discharge our duty in safeguarding national security, upholding the rule of law, and maintaining judicial independence. Thank you very much.
而家係答問環節，各位可以用中文或者英文提問。咁咧，我會建議每人可以最多問2條問題。咁發問前，首先講出姓名同埋所代表嘅傳媒機構，或者呢位先生先。
仲有新加坡，想問下咧，覺得如果人大釋法成功咧，同即係保障被告去聘請大律師嘅權利同自由，會唔會有個衝突啦？同埋今次即係第6次釋法啦，預計都係即係第一次就國安法去釋法。點樣去睇？即係如果人大去解釋呢個法例，即係對黎智英案嘅影響咧，預計個釋法嗰個需時幾耐？唔該。
嗱，保障被告選擇律師嘅權利咧，第一點我想提醒大家嘅就係，其實香港係有足夠嘅人才，大律師公會亦都喺香港有足夠嘅會員去處理國安法嘅案件。大家可能都有留意到，其實我哋公會喺第一次去潘兆初法官去處理呢個申請嘅時候，我哋嘅立場都係我哋唔覺得呢一單案聘請一個海外嘅御用大律師係會對案件有明顯嘅貢獻嘅，所以我覺得被告去聘請有能力大律師嘅權利，我唔見到喺呢單案件裏邊會有影響，而被告亦都係。雖則佢而家可能唔能夠聘請海外嘅御用大律師呢一個會當然受到之後人大常委決定影響啦。但係其實佢嘅律師團隊亦都係經驗豐富，而代表佢亦都係有相當有經驗去處理國安法嘅資深大律師同埋大律師嘅，相信大家都認識佢哋啦。所以呢一方面我唔擔心。至於你及後嘅問題會牽涉到一啲嘅揣測，就係人大常委會點樣去決定啊，同埋一啲嘅詳情。咁呢個階段同埋你頭先提到個時間表啦，呢個階段我相信我回答唔到呢一啲嘅問題啦。唔該晒你。
係嗰位恤衫淺藍色恤衫嗰位。
非常明報。今次呢個人大常委會嗰個決定咧，其實睇翻國安法咧，佢係 silent on 嗰個即係 Overseas Council 嗰個，即係明文上咧佢冇規定嘅。其實今次係咪一個變相嘅立法咧？都或者日後即係如果政府因為國安嘅考慮，即係引用國安法嘅宗旨咧，佢就可以延伸同埋詮釋個立法原意。譬如講，即係基於國安嘅考慮咧，就俾外籍法官參與國家安全法嘅即係相關嘅案件咧。第二咧就係今年1月咧 ，CJ 就話 Judicial Independence in Hong Kong exists as a fact。呢一句你覺得今日香港係咪成立？
嗱，第一件事就係今次係就國安法第一次釋法，同以往嘅釋法當然係有明顯唔同嘅地方。至於大家知道人大去釋法，佢實質上高會點樣去解釋呢？現階段我真係唔能夠去作出嘅揣測。所以當然啦，喺我哋見到有關嘅解釋前，可能大家都會有一啲擔心，有一啲嘅疑慮。但我希望大家都係會留意下釋法之後嘅內容，亦都睇下嗰個實踐，再去評論有關對於香港嘅影響。至於 Alvin 你第二條問題話 Judicial Independence exists as a matter of fact， 呢一個今年終審庭首席法官張舉能喺1月，我相信係法律開幕年度嘅時候所講。我相信今次嘅事件其實我就見唔到同司法獨立同 Judicial Independence 有好大嘅關係。我亦都唔覺得今次嘅事件會破壞香港嘅 Judicial Independence。大家要記住，其實國安法第65條呢個演繹同之前釋法一樣，其實係現有嘅機制去處理一啲我哋香港要面對嘅問題。所以你見到今日其實司法機構都出咗聲明，佢話其實佢哋都係尊重呢個決定。
但係你點出嚟去變相立法咧？因為個法例
我諗我哋要睇一睇之後有關嘅條文，我哋再去討論呢一個事情。
由於時間關係，呢個係最後一條問題。Can we have English question, please? The lady sitting at the back.
Questions from ASP. Mr. Dawes, you said you hope the power to interpret the law would be...
Can you speak up because of the mask? Yeah, sorry about that.
You said you hope the power to interpret the law could be used sparingly.
Yeah.
Do you think the Chief Executive have used his powers sparingly in requesting interpretation? And more importantly, is there a legally defined procedure for the Chief Executive to do this? Is his request a legally based one? Second question, has the bar all along known that the government would seek an interpretation when the bar joined the DOJ to oppose the omission? Does the bar regret joining DOJ? Was it a wrong choice?
Now, first of all, can I answer it backwards? Because we had no idea, frankly, that there was going to be interpretation under Article 65, of course. We're aware of that power. When the decision was reached to oppose the admission of overseas counsel in this case, it was pursuant to our usual procedures. And those of us following our judgments would appreciate that the bar opposing the admission of overseas counsel actually happens quite a few times every year. And it's especially in relation to first instance criminal trial. This is not the first time we oppose. And some of you may recall that the bar also opposed the admission of David Perry QC in the prosecution of a number of individuals, including some of members of the bar and other individuals in the appeal that is currently being heard in the court building today. So we say that the decision to oppose is one that is based on our understanding of the law. We did not take any extraneous considerations into account, and we certainly are not aware of the fact that there is going to be interpretation under Article 65. If anyone is to tell you that they know back then, I would be very, very surprised. Secondly, of course, we do have a standard protocol and procedures in deciding whether to oppose. So there's a committee in the bar populated by senior members to consider whether we should oppose admission in any given case. Such decision is then subsequently discussed by the Bar Council before the matter is decided by the court. So even in cases where we do not oppose, the admission of overseas counsel will involve a court order. The court will have to approve it, and they do not represent such decisions. So each and every case is considered seriously. And if you ask me whether there's any regret, we have certainly followed our usual protocol. And I don't think there's anything that we should be regret about. Also, you will also note, and I won't repeat it because our stance is set out in the judgment quite clearly. In each and every stage of the proceedings, we have taken a stance that is considered, and it is not simple opposition, full stop. And in that regard, I won't repeat our position because it's been recorded at every stage of the court's judgments. Sorry, I missed your other question because there were two.
You said the power to interpret the laws should be used sparingly. Do you think the Chief Executive has used his powers sparingly? And more importantly, is there any legal procedure to specify like what actual steps the Chief Executive can take to request interpretation?
The power, of course, that are set out very clearly under Article 65 of the National Security Law. And that is why you see in the Chief Executive's press conference yesterday and this morning, he has basically set out the steps that he has taken. And in that regard, I can only say that we are really dealing with the early days of the NSL. And under this situation, the court has considered the matter. The government has also stated their stance very clearly and have explained the position. Of course, using interpretation to deal with the situation will undoubtedly, as I've said, result in certain doubts or discussions about our legal system. Now, the fact that doubts are created, of course, is not a situation that is ideal, but I do understand the government's position and the reasoning given by the Chief Executive both yesterday and this morning. I'm sure some of you have attended that press conference. I'll answer one more question because there are so many of you.
I think you timed up my question. I was not asking about NDCSC's power. I was asking
The procedure.
The procedure, the steps took by.
Frankly, I'm not aware of any concerns in relation to the procedural aspect of what is going on because the power is there. I think it is very important, to focus on how we can deal with this expeditiously because we all know that there's an upcoming trial. The Chief Executive said there will be an adjournment, and it is really in the hands of the court in the forthcoming case to ensure that the defendants are being treated fairly in accordance with the safeguards that we have under our law.
So
Thank you. Why don't I? Yeah.
你好啊 TVB 嘅，我都想問翻咧，點樣睇琴日政府提出釋法嗰個理據咧？覺得佢哋係咪站得住腳咧？睇翻中院嘅判詞，其實佢都冇處理過係咪容許呢啲海外大律師嚟香港嘅問題。如果而家直接由人大去釋法嘅時候，係咪剝奪咗法庭處理呢個問題嘅權利咧？即係啱啱都提過，希望係去審慎咁樣去運用呢一個權利。你覺得而家呢一個做法係唔係審慎？近年釋法係常態化咗嘅時候，仲係唔係一個審慎咧？
唔該你。嗱，我第一我就唔覺得釋法你可以話係常態化咗，大家啲嘅都有好多討論。呢次係國安法第一次嘅釋法，之前有幾次就基本法喺97年到依家都有幾次嘅釋法。大家見到即係今日咁多記者朋友咁關注同呢幾日嘅討論，呢啲唔係經常發生嘅事，所以我絕對唔相信有常態化。海外大律師其實參與每一宗訴訟，如果涉及公眾利益，其實喺唔同嘅界別有唔同嘅觀點或者聲音，其實呢個係常情。但係我都明白，我哋都公會亦都強調，其實司法獨立當然係重要嘅議題，茲事體大。其實外界對司法機構行使裁決權唔受干預呢個信心，其實當然非常之重要啦。咁中院琴日拒絕批准上訴許可，法庭嘅裁決我哋當然係尊重。但係正如我頭先所講，喺現行嘅法律裏邊，喺《國安法》第65條，人大常委會係有明確嘅權力去解釋《國安法》嘅條文。佢哋亦都係可以喺適當嘅時候行使呢一個權力嘅，所以我都希望大家個焦點應該放喺之後個案件裏邊，被告人係咪喺我哋現行嘅法例裏邊受到足夠嘅保障呢？呢一方面，我相信處理案件嘅法官、處理案件嘅控方或者辯方，大家都有責任。而我亦都有信心，我哋嘅法庭可以俾到任何被告有公平嘅審訊機會。我諗今日我哋答嘅問題會係咁多，多謝各位。
擔唔擔心會搞指定律師制度啊？
今次釋法會影響埋海外律師嚟執法其他嘅刑事案件㗎？